matter of cellular technology limited and others, and A4 retailing is and others.
Mr Tatfield.
My lord, first, my profound apologies if I kept you waiting a minute or two outside. I had that awful realisation my printed submissions were in part yesterday's and in part my reworked versions tonight, which is the absolute worst of all worlds. Also, I hope that your lordships may have received a short clip of further materials, which I will ask permission to rely upon in due course in respect of certain points arising out of yesterday. In particular, there is, it relates to my learned friend Mr Nicholson's, what I submit as a new argument about the nature of the comparison or conversion which occurs at priority level 4. And the remainder, which is the bulk of it, goes to my learned friend Mr Birkhill's attempted resuscitation of the arguments of invalidity over Bordeaux. I'll address you upon those and seek permission when they arise, if I may, but I just wanted to check that my lords had them.
So speaking for myself, I've certainly got them. I think everybody, yeah, we all do have them. Yeah, thank you very much.
Right, my lords, we were at paragraph 17 of the patent. And as we say in our skeleton, paragraph 17 recapitulates paragraphs 14 and 15, in that it restates that the method as a whole, indicated by the number 100, functions to convert UMTS measurement information to a GSM measurement format. That's line 12. So using the above described method in accordance with the preferred embodiment of the present invention, UMTS measurement information from the mobile station can be converted to a GSM measurement format, etc. Now, all of this in our respectful submission is clear. The conversion of claims 1 and 2 is described...
Just ask you this question. It says can be converted. Doesn't say must be. Doesn't say is. Doesn't say shall be.
No,
it's an option.
It is an option, and this is my learned friend's preferable point, but it is the option which is the focus of which is the subject matter of the claim. So it's an option in the specification. It is not an option in the claim.
Well, clearly conversion is not an option in the claim. There's an express requirement of conversion, but the word format doesn't appear.
No, but every time conversion is discussed in the specification, it's discussed, and one sees this in 14 and 15, 17, it's discussed in the context of converting to a GSM format. And my lord will recall the last sentence of paragraph 14, which introduces the nature of figure 2, explicitly says that that is converting UMTS measurement information to a GSM measurement information format. That's the introduction, just above line just above paragraph 15 at line 41 and 42.
So, do I understand it to be your submission that the word conversion, or sorry, converting, let's use the word converting because that's convenient, both the same word in the claim and in the sentence to which you've just referred. Converting is inherently converting into a GSM format or into an appropriate format, or what?
Well, converting, or converted, which is the other word in the claim, is expressing or encoding the measurement from the first system, which in the example is UMTS being the claim is broader, in a manner such that it shares a format, it has the same format as the second system, which in the example is GSM, and that it is comparable with those GSM measurements. So a conversion is one thing, but you can tell what is a converted value because it has two characteristics. The one of them, just to reiterate, which is the one that's first introduced in the patent and is introduced in paragraph 14 and then paragraph 15 and figure 2 are meant to be examples of this, is the format characteristic. And paragraph 15 later introduces the comparability characteristic. And it's common ground the comparability characteristic is a characteristic. The debate is whether format is also a characteristic. And we say it is, and we say you see that in 14, you see that in 17, you see that because of the nature of steps 104 and 108, which in our submission are not replaced by the alternative 106, being an alternative to 106. We also say you can see that, I'm going to come on to the advantages discussed in the patent, but you can see that from the advantage in the patent because the patent is contemplating format substitutability is one of the things that is provided. It's not required to be taken advantage of in the claim, but it is provided by the conversion. And one sees this as well. The judge, this is what the judge accepted in, from recollection 93 of his judgment. He says it's, that's the conversion. Purpose, second sentence, is to render the UMTS measurement in a form, I stress in a form, both comparable with the GSM measurements and expressed in the GSM measurement format. And then he talks about the benefits. Some of the benefits. So conversion or converted values are a thing which are identified by two characteristics. And we say that is clear from the specification. And, that's, and we say the judge was right to conclude what he did conclude. So, my lord, I'll come back to this in the conversion section, but just to deal with that question my lord has asked.
Thank you.
And perhaps just to press it for what I will say, Apple's case in our submission is inconsistent with what's said in 14, and inconsistent with what's said in 17, and inconsistent with what's said about in paragraph 15 about step 104, step 108. Probably others to boot when I come on to it. Now, briefly then to go back to the advantages, which are referred to in the patent at 5 to 8 and also discussed in 11 and 17. My learned friend has made great play of the fact that claims are not limited to using the SATch or limited to a non-stealing mode. Although, of course, some of the claims are limited to the SATch, or to using a GSM message. And I'm going to expand upon this in a degree of detail when we come on to the Agrevo case itself. But he does so to try and persuade your lordship these statements in the patent are wrong or misleading. But in my submission, he misunderstands what's being said in the patent here. Because what in each of these paragraphs is being discussed is what the invention enables the skilled addressee to do, not that it requires the skilled addressee to do this. And this is really a fundamental point to the whole Agrevo argument. It talks and clearly uses the word can about what can be done. A non-stealing mode can be used. Measurement information can be conveyed without sacrificing speech quality. It's not saying the user must or has to do this. And it's not saying that a monopoly is limited to that, because it's not.
So, in your submission, the heading is deeply misleading. When it says summary of the invention, what it should actually say is advantages of brackets, some embodiments of close brackets, the invention.
No, not at all, actually, my lord. With respect, I completely say no to that. The invention, I'll say more than no. The invention, every time you take a value and convert it and use that value, you are put, as it were, as a skilled addressee, in possession of something which enables you to take advantage of substitutability, of the formatting, the commonality of formatting. You can use the SAT, you could use a non-stealing channel because the converted values enable you to do that. Now, you may choose in the wider system not to take advantage of that. You may take this thing which has those properties, and this is obviously going to be caught on the aggrieved argument. It has those properties. But what my learned friends posit is you might choose to use them in a wider system, which doesn't take all advantage of them.
Is your answer to my question, to put it more shortly, no? The correct heading would be advantages of all embodiments in the invention.
I think, with respect, I would say the benefits of the invention are always obtained in the sense of you always have.
What's the difference between an advantage and a benefit?
The advantages of the benefit are always obtained in the sense you are always provided with converted values which have these beneficial properties, which means you can use them in a system which takes advantage of them.
So is the answer to my question yes? One could appropriately head this section advantages of the invention, or if you will, advantages of all embodiments of the invention.
Yes, I think one can. And that's because I draw a distinction between I use the word benefits in my note just because that's how I've written it, but advantages which the invention provides, and then what I submit is a separate question, and this obviously I will expand on in some detail, a separate question as to whether the wider system within which you're using the method steps or the components of Claim 9 takes advantage of those advantages. And the reason I've used benefits, because otherwise I get advantage twice in the sentence, but takes advantage of the benefits. So the judge addresses this, and in my submission he gets it just right in 55 to 57 of the judgment. And whilst reading this, if I could sort of notionally ask my lords to undermine, I don't literally mean undermine, the words can, but to pick those up when they come through, they can be used. So you see, particularly in 56, but there's also a flavour of this at the end of 57. He says it's fair to note that paragraphs can be read as enabling rather than requiring the use of, here, the non-stealing channel. And that's what, in my submission, this is all about. 5 to 8 of the patent, and indeed the Aggrivo argument, one has to distinguish between what the invention itself enables and what advantage is taken of that by the wider system. And I'm going to come on to explain the Aggrivo head. We put this in 3 ways. One of them is really just, and they're all very intellectually, as it were, related. One of them is the way I've just put it. Another way, just again to foreshadow it, that I put it is if one looks at the law of the related area of breadth of claim insufficiency, it's very well established, and I'll show my lords this very quickly because it is established. It's a facile analysis just to say something falls within the claim, therefore it's a problem. The analysis one has to carry out in that context is a more sophisticated analysis which has close regard to the nature of the invention. And the third way I'm going to come on to is just by looking at the technical contribution. And I don't want to get too much down that line at the moment, but the technical contribution is a series of method steps or a series of components on a larger device. Now, the method steps or the components themselves do provide converted measurement information which has the beneficial qualities. And the point my learned friends make against me is that the wider system may be designed so as to not take advantage of those. And I say none of that matters. But that's the fundamental dispute between us, actually. My Lord Justice Arnold, you put your finger on it, really, by the questions that you asked me about the title above paragraph 5. Now, if I may, I was going to move on to construction, which is quite a... Well, I'll move on to construction, if I may. On Optis' construction, conversion is used in a consistent and constant way throughout the document. And what conversion is, and I've just shown my Lord's 93, is notating or encoding the measured UMTS values, or the measured values from the first system, in a manner such that they have the twin characteristics of the same format as, and being comparable with, the measurements from the cells in GSM, or the second system. And so that the measurements of UMTS can be treated as if they are measurements of GSM for those purposes. Now that's really common ground now. I can show my Lords how Mr Nicholson put it today at, I trust my Lords have a transcript from yesterday.
Yes.
But how Mr Nicholson put it at page 12, at lines 9 to 12, he says the basic idea of the patentee's solution is to convert the new UMTS measurements so they can be treated by the mobile phone and reported just as if they were GSM measurements, even though they are not. So that was T1, 12, 9 to, page 12, lines 9 to 12.
Yes, but he's there talking about the preferred embodiment, as I understand it, not the claim.
Well, my Lord, he's talking about the basic idea. So I'm just rereading. He's talking about the basic idea of the pattern. You have to bear in mind that the conversion is only described by reference to.
You have to start at page 11, line 25. The patentee prevents a burst embodiment, which we say, is a very specific and apparently complete solution as to how to solve this problem, illustrated by figure 2. It's in that context, he says, the basic idea of the patentee's solution is to convert. So what he's talking about is the first embodiment, the very specific and apparently complete solution to solve to solve the problem.
My Lord, maybe I shouldn't go too far down the route of arguing, my learned friend. What I would point out with respect to that is conversion is described in that embodiment. That's the only place where it's described. It's introduced in 14, if you recall, paragraph 14, which is describing the embodiments. And in any event...
Yeah, so your submission is straightforward. You say he's right about the embodiment, and you say the same is true of the claim.
Indeed. Indeed. But that's why the claim itself refers to conversion being to measurement values for the second communication system. Now, a point just of detail to pick up on. Note that this is not specifically about taking the 7-bit, just to use the UMTS and GSM argument, the 7-bit encoded binary value used to report RSCP in UMTS, and changing that into a 6-bit format. The claim concerns the converted values themselves, and is not concerned with by what route the conversion takes place. So it could be, for example, that the phone takes the...
I'm sorry, I don't understand that. You seem to be making two different points, and I'm mystified as to how the second one relates to the first. So you start by saying it's not specifically about changing 7-bit to 6-bit. Fine. Then you'd say it's not about the route. Okay, fine, but that's a different point.
Well, so I mean, by route I mean what you start with to get the before you get to the 6-bit encoded value in the GSM scale.
I'm sorry, there's two different concepts in play here, and I need to get them straight in my mind. One is what your starting point and end points are, and the examples are 7 bits and 6 bits. The other is what your route map is to get from your start to your end point. To my way of thinking at the moment, those are two different things.
Okay,
if I'm mistaken, please tell me why in simple words.
Can I? Yes, okay. What I'm going to submit is the claim doesn't specify the starting point, which could be set. So the starting point could be, for example, that you take the output of the component within the device, which itself measures the physical thing, and directly encode that in 6 bits with the appropriate, on the particular scale. Or sorry, maybe I should start. The starting point is fundamentally the thing that's measured. The measurement. Now you could take the output of your measuring component and, using the wizardry of a phone, record that directly in 6 bits on the particular scale. And so do what you might call a one-step conversion direct from the measurement information to the converted value in accordance with the claim. You could do this, though, taking more than one step. So, for example, you might record the output of the measuring device in some other format. It might be 24-bit waveform or something like that. And then subsequently converting that into...
I'm completely lost, Mr. Jackson. I'm very sorry. I'm sure it's my fault for a want of understanding. But I'm utterly lost as to what point you're addressing. I can quite understand the proposition that when the claim requires converting a plurality of downlink measurement values associated with said first system to a plurality of downlink measurement values for said second communication system, that would cover doing it in 1 step, doing it in 2 steps, doing it in 3 steps. It would also cover doing it, for want of a better terminology, directly or indirectly. That I have no difficulty with. But you seem to be making some different point about the starting point and the end point. And as to that, I'm less clear what you can be saying, because the claim specifies your starting point and your ending point. The starting point is measurement values associated with said first communication system, and the ending point of the conversion is measurement values for said second communication system.
My lord, it's definitely me, not you. I can tell you that because you've summarised what I was trying to say perfectly.
Okay.
The point, let me tell you what the target is, forensic target down the line. And it's that my learned friend Mr Nicholson makes a big play about how in a sense, and I'm going to come on to why this is a sleight of hand anyway, the 7-bit encoding of a particular RSCP and UMTS as sent to UMTS is, he says, the same, I disagree, as its encoding when sent to GSM in 6 bits. And what I'm saying is the claim doesn't require that comparison at all. It doesn't require that you turn the 7-bit value into the 6-bit value. It doesn't exclude an approach whereby that's one of the steps. I accept it doesn't exclude, but that's not what the claim is about. And you also see this when one looks at the formula in paragraph 15, because that's about comparing how RSCP and RX lev. So the forensic target is saying, although my learner from Mr Nicholson likes to talk about the comparison between the 7-bit and the 6-bit encodings for UMTS as sent to 2 different systems, that's not what conversion of the patent is about.
Well, I think we need to debate that when we come on to essentiality.
Fine. Now, Apple's case, turn to their case. Their case is that it has to be that conversion converted are used differently in the alternative step 106 in the claim from how they're used throughout, in my submission, the whole of the remainder of the patent, but certainly the substance of the remainder of the patent. And as we've already discussed in my submission, for Apple's case to be correct, it would require the skilled person to discard or ignore the teachings as to format in the second half of paragraph 14. In particular, the teaching of figure 2 is a teaching of how to convert to a GSM format, as well as much as 15 and paragraph 17 and steps 104 and 108. Now, this is what the judge is discussing in paragraph 78 of the judgment. And I can take my lords to that.
Yeah, so this is contextual interpretation. Yeah. The word converting is pretty meaningless in the abstract. One therefore is dependent upon the context to understand what is meant.
Indeed. But what is quite striking is that Apple accept that we Optis are right as to conversion in respect of the first version of step 106. That's common ground. But what they say is the position is different in respect of the alternative step 106, and that therefore the word conversion or converting is used differently within the patent and indeed within the same paragraph.
Well, you drew attention earlier to the word for, and it might be said, well, in order to be measurement values for, say, second communication system, they must be ones that are understandable by said communication system, which at any rate means that they are comparable. I appreciate you say yes, and it also needs to be in the same format.
Indeed, I was going to say this. The reason it's the word for, it can't, in my submission, be for another system if you can't actually fit it in that system. So I entirely agree with what my lord just said. Now, Mr. So the reason I was pausing is whether the value of going to Mr. Simmons, Apple's expert. Even he, in cross-examination, he had a point on the language, but even he accepts that the skilled addressee reading the patent would understand that the intention of the writers was that alternative step 106 was only a substitute for step 106 and not the remainder of paragraph 16. Actually, if I may, I will show you this because this does, the construction of this term does impinge on technical considerations, and so the views of experts are of relevance there. It's in supplemental bundle at tab 15, day 3, and page 248 of the bundle. And if I could ask your lordships to read from 375, it's page 248 of the bundle, 375 of the transcript from line 16 down to the bottom of, so line 25 of 376. It's only really the last few lines of 376 that matter. It's just the question is a little difficult to understand unless you've read the build up to it. So he's accepting that was the intention of the writers. Now we don't accept his linguistic points either, but even he accepts that when the skilled person reading this would understand the intention of the writers is that the alternative step 106 was only a substitute for the original step 106, and that's obviously contrary to Apple's case as well. My own friend says, read on. Now, the other point I wanted to touch upon here is that it is actually quite unclear to me what Apple actually mean when they say that conversion requires comparability but without any limit as to the format. And what they are positing is that numbers relating to different systems may be comparable even though they're expressed in a different format.
And what's the problem with that? Take binary and decimal.
Well,
Format is different, but you can compare the two.
well, indeed. But my learned friend, he put this by reference to the figure he extracted from Mr. Simmons's evidence, which is at page 14 of his skeleton argument. If my lords have that. And actually there were 2 points that come out of this which are worth noting in my submission. So first he draws a notional line across the table, say at the minus 112 decibel milliwatt level, so that's next to 4. And what he does, he reads across that both the middle and the right hand columns are a 4. So he says there's no change. But in my submission that is a sleight of hand. First, it shows that in fact there is a difference because there are in different numbers of bits. But what my learned friend has done here is to try to obscure his problem by describing the 2 different types of UMTS encoding in terms of a human readable decimal 4. But that in itself is to align their formats. Here is decimals, human readable decimals, which makes the comparison possible. Now, so what he's done is he's done a change of format and says they're both 4 and they're both the same. But there's no way, as I understand it, there's certainly no evidence that a computer can compare things that are expressed in a different format, a binary number and a decimal, my lord just mentioned. Or a decimal and a
computers
hexadecimal.
do that all the time.
Well, they do that by changing things so they all then tie up. And my point is that you can do it if you do a change that then puts them all on a common format. And that's what he does when he calls them a 4, both a 4. But what that shows is that he has to do an additional step to make them comparable because their formats are different. Now this isn't, I'm not going to suggest this is the main point, but it does to me raise the question as to what he really means by saying there's comparability without commonality of format. In a sense, yes, a computer can. If you put a 4 in and you put a 7-bit binary of 0000100, the computer can do a bit of computer thinking and work out that they're the same. But it does that because it has to turn the 4 into a 7-bit binary or the 7-bit binary into a 4.
I'm probably being stupid. The only difference is whether you add on an extra naught.
It is, but in a computer those kind of extra noughts are quite important because it puts all your registers out of kilter. If you slip an extra naught in, the way you may recall from the skeletons, there was an example of a message. It's a slightly different context. And what happens in the messages is that every single bit has a purpose. So when I'm addressing my lords, at least in theory, my lords understand what I'm talking about because I've given it a context and explained. But in computing terms, particularly where resources are very limited over the air interface, that's very inefficient. So what happens is that the system is set up so that every bit has a purpose. You don't have to explain what the bit means because you understand from its context and where it is in the message. So if one slips a 0 in, that just means that pushes everything else out of kilter and the message becomes completely meaningless.
All right, I follow the point, but this is a bit different from the ultimate message where each bit has a purpose. This is just whether you, in expressing in binary form, take account of 7 places or 6 places.
Sure. I completely accept that. That's absolutely right, my lord. But at least as far as I understand it, and there's no evidence on this at all, my my learning friend's case, a 6-bit number can't be compared with a 7-bit number because the registers are different size. You'd have to turn them both into a 7 bits. And you have to change their format. Now, I don't want to spend too much time with this. I said that, you know, my main case is based upon, you know, the wording and all those other things that I've addressed you on. But certainly from my point of view, my point of view, I actually find it a bit obscure as to what he means by this, by having comparability where there isn't the same format, because I don't really understand how that's supposed to work, other than by imposing another step which aligns their formats. Now, the other point I'll make just whilst I'm on this table is the way my learned friend used this is he likes to compare the middle column and the right-hand column. So that's RSCP as reported to GSM and RSCP as reported to UMTS. But as I've showed my lords and explained by reference to formula in paragraph 15, what the patent is concerned about is a comparison between the left-hand column and the RSCP value in the centre. And that's what's the subject matter of the formula 15. And the judge held, and I'll come on to this when we come to essentiality, that in fact there is an offset between the two of 5 decibel milliwatts. What I'm really saying here is this just demonstrates he's shooting at the wrong target on that part of the case. Now, what then does Apple say? Well, Apple's main point, it says, is the judge wrongly read in limitations from the claim. And they cite Nokia and IPCOM on that. Now, that's wrong in my submission. The way what Mr Burkill said yesterday, this is at T1 lines, page 70, he said, where a patentee uses words like preferably in his description, but the preferred feature is not in the claim, one cannot read the claim as including it. But in a sense, that's exactly the problem in my submission for him here, because the question is not about reading in additional limitation. It is about construing an integer which is in the claim, namely the converting and converted measurement values. And this is what the judge was alluding to in 94 of his judgment, where he refers to he says he's not reading the gloss and the specifications of the claims to interpret the claim in its proper context. And that, in my submission, is exactly right. Page 86 of the bundle, paragraph 94 of the judgment.
Which words of the claim are we really concerned with in this part of the argument?
It's in integer 1b, it's converting two measurement values for the second system. And the word also arises in the next integer where it talks about converted values.
Really, integer b is the
It's principally integer b. The word converted does appear elsewhere, but really the focus is on what a converted value or what the converting produces.
And there's a good reason for that, because wherever it says converted, it says said converted. So explicitly it's referring back to the conversion that you've done at step B.
Yeah, completely. There's no real... indeed, absolutely. Now, Apple makes several further or make-weight arguments, which I addressed in my skeleton from paragraph 64. First, they say, and this is paragraph 35 of their skeleton argument, Apple assert that since the comparison with a threshold may provide fewer or more than exactly 6 results, and the then standard GSM message, they say that the then standard GSM message could not be used, since they say the skilled person wouldn't know what to do. So the argument is aimed at the target of trying to say the skilled addressee would know they had to avoid the standard GSM message when using the alternative form of step 106. Now, this whole argument in my submission assumes an absolutely facile level of intellect for the skilled addressee. If you have fewer than 6 UMTS cells, you can fill them up with GSM cells. Or indeed, if you don't have enough cells, you can leave them blank, and they could be left blank in the original message. because there may not, in GSM alone, there may not be 6 cells you're reporting, there may be 4 or 5, 2. And if you have more, you just send the best 6. Now, none of that's other than trite, and the judge rejected this argument in paragraphs 79 and 82 of the judgment. So that's 79, and then also 79 is the main one, but 82 picks up on it as well, and that's on page 84 of the bundle. So in my submission, there's nothing in that point. And there was evidence on this. This was based on the evidence from Mr. Thomas. I can find the reference, it really matters. Apple also argues that the word value is apt to only refer to the numerical result, and it cannot have a format characteristic. And your lordships may recall, I referred you to paragraph 49, was it 22? It's for paragraph 49, sorry, it is paragraph 49 of my learned friend's skeleton argument. I think I referred you to that yesterday. But that argument is wrong for the reason which I mentioned to your lordships yesterday. The term measurement values is used synonymously with measurement information in the patent. And it specifically does so in the patent in the context of the first version of Step 106, where it's common ground that both of the characteristics of format substitutability and comparability are present. So that, in my respectful submission, doesn't work, and the judge points this out in paragraph 95 of the judgment.
I'm not sure it matters, but you acknowledged yesterday that your use of the expression format substitutability was your own convenient forensic shorthand, and that you could express it in other ways. And I'm a little puzzled as to why you'd call it substitutability. I mean, the point is, it's the same format, isn't it?
It is that. I know Brendan told me that about 2 days ago. By then I'd written substitutability down too many times to make that change. My lord's absolutely right. Yeah. It came to my mind because the reason it's there is for substitutability, but in fact the physical thing is it's just the same. 6 bits. Okay. You're absolutely right. So my lord, sorry, subject to any further questions, that's all I was going to say on construction.
You referred to paragraph 95 of the judgment in this context. Do you want to take us to it? Or?
Oh, sorry, my lord, yes. So paragraph 95 of the judgment, what the judge is he's making the same point there that I was making orally to my lords, which is the word values is used in the specification, and particularly in the context of the original Step 106, in a way that's interchangeable. It's clearly interchangeable with measurement information, and is used in a context where the conversion that's being considered is common ground in the first Step 106, is a conversion with a format characteristic, the same format, and comparability. And so it's clear that this, my Lord, Lord Justice Warby may not necessarily pick up on the magic words 5 lines down, the meticulous verbal analysis in 95. But like all branches of law, those are magic words which say they're making a mountain out of a molehill. But I go further and say it's not just a mountain out of a molehill, but it's positively, clearly wrong when one looks at actually the context in which the word values and information are used in the specification. Now, essentiality and infringement. So, my lords, 3 allegations of essentiality or infringement were advanced by Optis in closing, and all were accepted by the judge. The first relates to reporting the UMTS RSCP values in what's known as enhanced measurement reporting in release 5 of the standard. And
why do we need to consider any more than that? Because I don't understand Apple to suggest that they don't infringe the other 2 if they infringe that one. Likewise, I don't understand you to say that they do infringe the other 2 if they don't infringe that one. So we can restrict our consideration to the first one, can't we?
My lord, I was going to say that. I was just making sure, just trying to make it clear what the allegations were. I completely agree, and I think that's absolutely right. So, but just for context, you've got the enhanced measurement reporting in release 5, and then in release 8, you've got enhanced measurement reporting of UMTS and LTE, and you've got reporting of the UMTS cells in normal measurement reporting. Now, the judge set out the basic facts of how the systems operate in paragraphs 111 to 123, and he records 124. There's no real dispute on this, but nonetheless, although my learned friend did take you to this yesterday, I think it will be helpful to pick up some more of the details, if I may, with your lordships now, working from the standard in supplemental bundle tab 3. And if I could start at page 24 of the bundle, which is section 8.1.1. So this is just setting out the generalities. The receive signal level may be employed as a criterion in RF power control, that's controlling the power of your radio link, and handover processes. For cells of other radio access technology, RX level is replaced by the relevant measured quantity for that system, C 8.1.5. Then over the page, one has 8.1.4, which sets out the encoding for the GSM RX lev quantity. And it just describes the mapping. The measured signal level should be mapped to RX lev on a value between 0 and 63 as follows, and then it sets it out. And there's a reference there to a thing called scale. This was part of the case at one point, but by closing, Apple dropped it as having any relevance. So that sets out that encoding. And then in 8.1.5, which is the bottom of that same page, this addresses the encoding for the other rats. And my learned friend took you to the top of page 26, which sets out the RSCP mappings. The first 4 lines. Now, what you can see here is it's reported in 64 steps, or buckets, as they were sometimes referred to at trial. And the point of buckets is because each captures a little bit of the range. But because it's 64 steps, it's encoded in 6 bits. And what you can also see here, if you flip from that to the previous page, is that there's a 5
It's the other way around. It's because you've only got 6 bits, it's encoded in 64 steps.
There may be chickens and eggs, but I'm not going to go in a ditch, die in a ditch on that one, my lord. Yes, indeed.
You're limited to 64. It's as simple as that.
It's hard to have many. Yeah, indeed. Right, yeah, indeed. My lord's absolutely right. My lord's right. Now, but what you do notice, there is a 5 decibel milliwatt offset between the RSCP mappings, which we're looking at now, and the RX lev ones on a page ago. And I've shown you the table in my learned friend skeleton, which set that out. But the judge explained this quite clearly in paragraph 119 of the judgment. If I can ask you all to go through that, it's 89 of the bundle, 119 of the judgment. So as you see, the R at the end, it says the RX lev for integer 63 represents greater than 48, whereas for RCP it's greater than minus 53. So what the judge is getting at here is that although in the standard the RSCP level is expressed via a lookup table which has a 5 decibel milliwatt offset from the RX lev table, they've got different tables. In mathematical terms, that's just the same as adding 5 decibel milliwatts to the RSCP values, and then you could read them off the same table. There are no different mathematically those approaches, either in function or outcome. Now, going back to the standard, if I can pick that up at page 28, which is section 8.4.1. And if I can pick that up halfway down at the, there's a little bullet point or a dash which starts RX lev. You can ignore the paragraphs above which says in the AGB mode when on a TCH or an IU mode. Thankfully, one of the experts said, don't worry about that. Nobody has since, so that's convenient. What you see, though, in the bullet-pointed paragraph is that the GSM device shall report the 6 cells with the highest RX lev. It then says amongst those are known allowed NCC Part B6. That just means ones it knows about. And then it says where the device is multi-band, and as my learned friend, one of my learned friends explained yesterday, I think it's Mr Nicholson, GSM was split into 2 bands, one at 900 megahertz and one at 1800 megahertz. And a device that can operate in both is a multi-band device. Because where there's a multi-band device, the number of cells for each frequency band supported, which shall be included, is specified in 8.4.3. And if it's multi-rat, then you look at 8.1.5, which we just saw, and 8.4.7. Now, we don't need to look at the multi-band reporting, although I am going to make submissions on it in the context we're going to come on to. But if your lordships could turn to 8.4.7 on page 32, and if I could just ask you to read the first paragraph, which is the beginning of the discussion about multi-rat mobile stations. Now, within this, I obviously stress the first and last sentences. The multi-rat MS shall report the number of best valid, just means that the cells that appear on its list it's allowed to look at. Best valid cells. And then the end, the best cell is the cell with the highest reported value, C subclause 8.1.5, which we just looked at. These are the best cells. Now, this is of obvious relevance given the discussions between my Lord Justice Newey and Mr Nicholson yesterday. Now, over the page on page 33, one comes on to section 8.4.8 on enhanced measurement reporting. And it's what we're interested in is how the report is filled up under section 8.4.8.1. Now, you may recall my learned friend took to the judgment there, and the judgment, I think, is pretty accurate, but I would like, well, is accurate, but I would like to take it from this document. And you see here that the 4 reporting priorities with the bulleted number 1 to 4. And the first is the number of strongest GSM cells within the frequency band. So this is in-band GSM cells. And as my learned friend said yesterday, there can be between 0 and 3 of these reported. Second, you have the strongest GSM cells from the other frequency band. And again, it's 0 to 3. Third, level 3 is the infringement. And in that, you have the best valid cells with a reporting priority which exceeds the threshold, which is XXX reporting threshold, and again, up to 3 of them. So this contains the threshold relied upon for the infringement. And as my learned friend explained, XXS can be GSM for GSM or FDD for the UMTS FDD, etc. And you may note that there is a further threshold, FDD reporting threshold 2, but nothing turns on that. In the original trial against Huawei and Samsung, there was a point made about that which a judge rejected, and it's not suggested anything in terms of that in this case. And then you get to level 4, which is the important part for the argument over comparability, the comparability characteristic. Now, so the important part is level 4 is the remaining GSM cells, and then there's a whole bunch of words with a known valid BSIC or with indicated by a parameter, etc. And then 3 lines down, and valid cells of other radio access technologies. So you've got GSM cells and cells of other radio access technologies. And as I said, valid just means appears on the list that you're allowed to look at. So what's important here is at this level there are GSM cells which are both in-band and intra and interband, and there are cells from other rats, and they're lumped together. And that raises a question of what to do. Well, in fact, all of them raise a question of what to do. There are not enough candidate cells to fill the available slots at a particular level. Or there are too many. And in particular, what happens at the 4th priority level where GSM and other rats are considered together. And that's addressed at the bottom of the page, where you've got the paragraph starting for each of the priority levels above, the following shall apply. Now, the first bullet point deals where you've got fewer cells and doesn't really concern us. But the important one is the bottom one. If there is not enough space in the report for the valid cells, the cells shall be reported. That has a higher sum of the reported value, RxLev, or as defined in the subclause we looked at earlier, and the parameter blah 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 offset for the respective radio access technology mode. Note that this parameter shall not affect the actual reported value, and the last sentence doesn't really matter. So there are 3 things which arise where there is not enough room. There are 3 things to note. There is a comparison between cells to work out which should be sent. And at level 4, therefore, a comparison between cells in different GSM bands and different rats. And as we saw a few minutes ago, we're trying to determine the best cells. The comparison is done, that's my second point, based on the RxLev or the corresponding other rat measurement to which an offset is added. And third, the offset does not affect the reported value. It's a value without the offset that's reported. And finally, if I can take your lordship to page 40 of the bundle, and halfway down, or just below the top hole punch, you find the description of the XXX reporting offset, the offset we're concerned with. And 3 points to draw from that. Firstly, you can see in the second column under the description, the purpose of the offset is described as being to prioritize cells for reporting between GSM frequency band or RAT. Sorry, for reporting for GSM frequency band or RAT. It's about giving priorities to the different radio access technologies. And obviously I'm going to come on to some of it. That's clearly supportive of my case on this. Secondly, it applies to different rats and to different bands, and I'll come on to, it's the bands I'm going to come on to here, or stress here. And just thirdly, I know it's quite granular. It's in 6 decibel milliwatt steps. So we're considering relatively fine adjustments.
It says it's dBs, not dBms.
Oh, it does. Well, you're right. Well, if it's in fact, it may depend on what you're reporting. It would be dBm through RxLev. It would be dB. Well, the steps are quite small. The units. I think it might be to do with the fact it's a logarithmic scale, and it's the addition of an offset in a logarithmic scale. But somebody who actually understands physics might have to answer that.
Well, we know that decibels are a logarithmic scale. Yes. Yeah. So what?
My lord, I'm afraid I can't tell you why that's decibels, not decibel milliwatts. Can I think about that one over lunch?
All right.
Now, my lords, I've taken a bit of time on this, so your lordships have the full picture. But this is for what for your note, the judge summarises in 120 to 123 of the judgment. Now, when it came to essentiality and infringement, the only dispute between the parties is whether there is a conversion in accordance with the claims. Now, that's principally a fight on the facts. Entirely, I think, a fight on the facts. And as to those facts, the judge correctly found my submission.
I assume you would accept it involves two elements. First of all, construction of the claim to interpret what the word converting means. And secondly, once you've construed the claim, finding the facts to see whether there is converting as so construed.
Yes, as a matter of principle, although my learned friend, Mr Nicholson, if you remember, he presented his case yesterday saying that this part of the case they present on the basis that I'm correct on construction. And I think the reason they do that is...
To be sure, but you still have to apply the construction to the facts as found.
That's of course right. But sorry, the point I'm making, my learned friend's approach at my construction, the reason he does that is because it's plainly there's a change from 7 bits to 6 bits. So the formatting, I won't say formatting substitutability, the commonality of format, that characteristic is obviously satisfied. Whether that's relevant or not doesn't matter because it's obviously there. Now, in my submission, the judge correctly found the encoding of the RSCP values for reporting to GSM satisfies, obviously, the formatting aspect. And we would endorse the judge's findings at 128 to 130 on that. I'm not sure I need to take my notes to those. But what the judge then did, he considered the comparability characteristic of conversion, of converted values, from 131 to 141. Now, his conclusion at the end is at 141. I can ask my lords to remind themselves of that. I know that you've seen it before. Now, given how my learned friend, Mr Nicholson, developed his submissions yesterday, I think it's important, however, to start by setting out the basic arguments between the parties and how they were addressed at trial. So the fundamental point at trial between the parties concerned the comparison made at priority level 4 between the measured values plus offset for one system, say UMTS, and the measured values plus offsets for the other, GSM. Now, it is and was Optis' case, and the judge accepted this, that the encoded values from each system are themselves comparable. Indeed, they are compared to determine the best cell. And the offsets are added so as to bias the comparison in favour of one system or another. And that might be done, for example, for network load balancing purposes. If one system has a lot of users and one fewer, you may want to move them over. Or it may be to bias traffic towards or away from the network system for other technical or even commercial purposes. You may get paid more if they're on UMTS. And this was summarised, our position was summarised by the judge at 133 to 135 of the judgment. Now, Apple's case at trial was that the measurements of each system are not inherently comparable, but that they were pulled into alignment to give comparability in level 4 by the applications of the offsets. So their case at trial was not that level 4 didn't have the requisite comparability. The argument at trial was that the comparability was not inherent in the encoded values, but was created by the subsequent application of the offsets. Although they also accepted the offsets could additionally be used to give a bias. And the judge set this out at 136 of the judgment. So you see, Apple contends that this is all wrong because it ignores the offsets. Apple agrees that in order to meaningfully compare the two values, it's necessary for some conversion to take place, but contends that the necessary conversion is provided by the offsets, which are controlled by the network. Note that it is the values without the offsets which are reported. So Apple argues that whilst it's true that the values are converted in the phone for the purpose of direct comparison using the offsets, nevertheless, there's no reporting of the converted values because they're sent without the offsets. So at trial, it was both Optis' and Apple's case that comparability does arise at level 4. Just for completeness, the judge then records Optis' responsive argument in 137. Well, that really is fairly repetitive, 133, 135. But if I could just ask you to see what's said there. So, sorry, this is a repetition, but the debate at trial was not as to whether there was comparability and indeed conversion at level 4. It was common ground that it was. The debate was as to whether this was inherent in the encoded UMTS values, which was my client's case, or that comparability was brought about by the offsets with the encoded UMTS values not being inherently comparable.
And just so I get the context clear, you couldn't rely on the offsets as conversion because what was reported was the pre-offset values.
So if Apple was right, had been right, then there was a converted value at level 4, but something different was reported at level 3, where the threshold is which is the infringement. So my lord has it absolutely right. Yes. Now the judge had extensive evidence and argument and cross on this, and he resolved this on the facts in my client's favour. Now, my learned friend yesterday, I think, disavowed any attack on 141 of the judgment.
No,
and only
no, that's not correct.
Oh, well, I was going to deal with both anyway.
He said it was A, inconsistent with 138, and B, even on its own terms, incoherent. And C, wasn't applying the judge's construction. Those were the 3 points.
Well, my lord,
all of which were attacking that paragraph.
Besides those 3. Well, my lord, a point my learned friend majored on yesterday is he raises a question as to whether the comparison at level 4 was a good or a useful one. Now, there's 4 answers to this, because what he was saying yesterday, and I touched on this when I first stood up, is if the comparison at level 4 is well, he said rough and ready, though sometimes he veered, I think, towards almost saying arbitrary. He says if it was of that type, then it's not good enough to satisfy the claim. That's what he's saying. And I've got 4 answers to this. First, it was common ground at trial that this was a comparison. I've just shown you how the judge recorded the arguments at trial. And my learned friends raised no evidence to suggest that there was any doubt about this, and indeed there's no appeal on that, as far as I'm aware.
Just to be clear, when you say was a comparison, I mean, Mr. Nicholson postulates a comparison, but he says a rough and ready comparison would have been good enough. You say not merely rough and ready, but to find the best.
I say to find the best, indeed. A useful comparison or to find the best. I also say, and I'll show you this in a moment, that my learned friend at trial accepted that actually rough and ready was good enough. I'll show you this. So, the next point I was going to come on to was indeed the standard. The standard says best, and my lord has that. The next point is actually I'd like to show you, if I may, a bit of evidence on this. And this is, if I may start with Mr. Thomas's first report, which in the supplemental bundle at page 132, in tab 5, page 132. And if I could ask my lords to read paragraph 275. Just to explain this, Mr. Townend, who's referred to there, was Huawei's expert in the first case. And because Mr. Thomas had appeared in both cases, in order to try and give a properly balanced report, he picked up on points that had been raised in the first trial in writing the report for this one. So that's why he appears. So he says clearly designed to select the most appropriate cells to report. Now, Apple's expert, Mr. Simmons, described it as a useful comparison, or it can be useful to compare. And this is his second report at paragraph 63, which is in tab 8, page 203 of the supplemental bundle. So obviously he disagreed as to how the utility arose between the encoding and the offsets, but he agreed, what he says is, so there's 203, paragraph 63. It can, however, be useful to compare GSM and UMTS received signal levels in dBm by the use of appropriate offsets. For example, for the purpose of ranking at priority level for the asserted standard, the network provides such offsets.
Yeah, but the key point there is it's the network that's providing the offsets, and therefore it's not going on in the phone.
Oh, completely. He didn't agree as to what gave the comparability. But the point I'm addressing my lord on is the fact that once you've got value plus offset and value plus offset and you're comparing, that is a comparison that is a useful one or there to provide the best cells. It's not one that is of such a poor quality, yes, but it doesn't satisfy the claim.
Let me put to you how I understand this paragraph, and then you can tell me if I've misunderstood. I think what the witness is saying in this paragraph is, first you report the value to the network, the mobile reports the value to the network. Secondly, the network applies an offset. Thirdly, the network then makes this useful comparison.
No, the network provides the offset. What he's talking about there is the network sends the XXX reporting offset to the phone. The phone applies the offset on the phone to the measured value and then does the level 4 comparison.
That's right. I'm grateful for the correction. But even so, you still have the point that what's reported is the original value, and then there's an offset that's provided by the network.
Oh, sure. So there's 2 points I need to address your lordships on, and I will, and I'm only doing point 1. The point my learned friend raised yesterday is whether measured or encoded value plus offset, the comparison that occurs at level 4 between encoded value plus offset and encoded value plus offset, as a whole, provides a good or useful comparison, or whether it's so rough and ready as to fall outside the claim. And my submission is, on that point, it's there to identify the best cell, or it's a useful comparison, etc. I'm also going to submit very shortly that in any event, my learned friend accepted at first instance that all that was necessary was a rough and ready comparison anyway. And I'll show you that, and in fact, to my next point. The second point which I will address your lordship's on, which was the fight at trial, is whether the comparability that arises from the values themselves, or the encoding of the values themselves, giving comparability which can then just be adjusted by offsets, biased by offsets, or whether the encoded values are non-comparable but brought into sufficient alignment by the offsets. And that's the second point, which I think my lord was just referring to. So I'm going to address both.
Yeah.
So the last
although
point...
I'm not sure these are really two separate points. I mean, I think you're right to distinguish between them, but they're related to each other, aren't they?
Well, yes, there is a degree of interrelation, and I don't think one benefits much discussing the extent of that degree.
Yeah.
So the last point I wanted to mention was, as I've said, Apple agreed at trial the patent was not in any event demanding absolute precision. A test was good enough. A test of good enough was fine. Can I show you? It's on page 2 of the clip I had sent to my lords earlier today. Obviously, I need my lord's permission to rely upon this, and if my learned friend wishes to object, then obviously I've got to give him the opportunity to do so. So page 1 is just the cover page of his closing skeleton chart, so my lords understand what I've got here. And page 2, it's paragraph 62 of that skeleton that I wanted to draw your attention to. So they're saying all opening Optis contended that comparable amounted to being good enough to provide a useful comparison for purpose of handover decisions. Apple does not disagree. Blah blah blah. Precise equivalence is unnecessary.
Yeah, all right, but one needs to have the rest of the submission because they go on to say, however.
Oh, completely. But what they go on to say is the point that the comparability arises out of the offsets, and that the underlying values are not comparable. So they go on to take the second point, but this is just on the first point here.
Okay.
Can I just think that through a moment? That point does help you, does it?
Well, it does.
Mr. Nicholson says, well, all that's required by the standard is rough and ready, and we can infer from that there was no conversion at an earlier stage, or need have been no conversion at an earlier stage. And I think he accepted that if a precise comparison was required, one could infer that there was a conversion at an earlier stage. Now, if he had said at first instance, well, there obviously has to be a precise comparison, that, as expressed in current terms, would tend to suggest that there had been a conversion at an earlier stage. But here he's saying the opposite, is he?
No, not at all. So
No.
In fact, paragraph 136 of the judgment, which I showed you, is the record of them having said at trial that a precise comparison does arise, but then coming to the second stage of, is it because of the offsets?
All right, but I'm sorry to interrupt you, Mr. Jacksfield. The point my lord is making is that what's said in paragraph 62 is no different from what Mr. Nicholson said yesterday. Yes, good enough to provide a useful comparison for the purposes of handover decisions is a fair criterion of what the claim requires.
Yeah.
But the question is what's going on in the alleged infringement.
Okay, my lord, sorry. Let me unpick that. There, as my lord rightly pointed out earlier, you have to think of two things when you're considering infringement. What happens as a fact, and then think about the claims. Now, my learned friend has been submitting yesterday that the comparison is rough and ready. And you have to then ask yourself, well, why does he say that, having regard to the claim? And what is implicit in that is he says, excuse me, the claim is only contemplating a precise comparison, and that an imprecise or rough and ready comparison doesn't fall within the scope of the claim. So he's positing that a rough and ready comparison isn't an infringement or doesn't result in essentiality because it's not good enough for the purpose of the claim.
No. It's, as my lord puts you, the argument is about whether you can infer conversion. As my lord has just put you, the argument is you can't infer conversion from a rough and ready comparison, whereas you could infer it from a precise comparison.
But that depends, if I may, on the meaning of conversion. One of the characteristics of the conversion, the converted values, is the comparability. But then we've now gone on to another level of granularity, which is the question as to the degree of comparability that is required. Because if conversion is only satisfied by a precise comparability and on the facts, and obviously I've shown you the facts and disagree strongly on this, but and on the facts, level 4 didn't give you that kind of precision, then he would say he's outside of the claim. Now I'm responding to that in two ways. The first points I've been making with the evidence I've shown you in the word best in the standard is that in fact level 4 is about a precise, useful conversion. The second point I'm making is even if I'm wrong on that, then the claim or the comparability characteristic doesn't require a huge degree of precision, and so a rough and ready comparison is enough.
But there must have been some conversion. So
Yes.
on any view, one must be able to infer that the standard requires some conversion.
Yeah.
Maybe it only requires conversion to a sufficient degree to achieve a rough and ready comparison, but it requires some conversion.
Well, it requires a conversion, just to put it if I can in slightly different terms, it requires a conversion which results in encoded values which have a degree of comparability. And the question that I'm addressing here is whether that degree of comparability has to be an extremely precise one, or it has to be good enough to be useful, which is how it's put in the skeleton.
Well, good enough to decide which is best.
Well,
you rely upon the parts of the standard that says that's the purpose of the exercise, is to find out which is best. And if it doesn't tell you which is best, why is it useful?
well, yeah, I'll put it the other way around. It says it's the best, and in one sense, that's probably, my best point is probably it says it's the best, and that's got to be good enough. Now, if I may, I was going to go on to the other aspect of which I've addressed you on, which is whether the judge was right in paragraph 141 to say that the comparability, the comparison, or the comparability which clearly does arise at level 4 because the comparison is done, whether that arises, as the judge found, because the encoded UMTS values are themselves comparable with GSM values.
Well, having said apparently the opposite in paragraph 138.
Well, my lord, shall I pick up on 138 now? All 138 is doing. Let's just read this, because my learned friend picks up one sentence. So here the judge is considering who's right, as it were, and I've shown my lords the competing arguments. In my judgment, Optis' approach is the right one. I was not persuaded by Mr. Simmons' approach to this. The fact the patent does give an example equation in which constant offset is added to RCP to make it comparable to RXF does not mean that the existence of a method which allows constant offsets to be used for prioritization between RATs proves the values before those offsets were added were not comparable. They may or may not have been. There he's just phrasing the debate. He's saying you can't say because there are offsets therefore the values are comparable, or they're not comparable. He's saying you have to look at all the facts to determine it, and I'm going to show you some of those facts.
I quite follow that. Isn't what he's saying is that the possibility of comparing after an offset doesn't show that you could compare before the offset. It may or may not be the case.
Indeed. He is saying that. And my case is not just there are offsets. My case has got, I'll show you the fact, my case has got more elements than just, a bold assertion. And I'm going to show you that.
Okay.
But he was essentially dealing with the submission that offsets were needed to achieve comparability. You couldn't, given the existence of offsets, there could not have been prior comparability.
He's addressing the submission by Apple that because you've got offsets, there couldn't be prior comparability, my lord. Yes.
Yes.
Yeah. So it's just framing the debate we've got. And if my learned friend puts to me the judge needs to, a judge at trial needs to consider all the facts that are put before him or her and then come to a reasoned view, that's all. I'd accept that, and that's all this is saying. Now, I'm going to show my lords 4 things. Firstly, obviously this was supported by the evidence, and I've set out 2 paragraphs of the evidence from my expert under paragraph 80 in my skeleton argument. If I could just show you those.
Right, if you're going into evidence, maybe we should give the shorthand writer a
Oh yes, I'm so sorry. I'd forgotten about that.
Apologise.
My lord is quite right. So we'll rise for 5 minutes or whatever is required.
Okay.
Don't think we're on the. Should we?
How are you doing on timing? 5. I'll finish 5. Or afternoon.
Yeah. Sorry about when in the afternoon?
Tomorrow.
Sometime today.
I've got till 3:25.
Okay.
He
He says he's got 3:25. He thinks.
That's his entitlement. He's going to use it.
So when my side does.
Yeah.
I'm going to go to this.
It was us. I think I'm pretty sure that this bit is you. You were all on top of this stuff and I was at the time.
Yeah.
But it's a work of joint authorship.
Oh, completely. I just genuinely.
Although, for better or worse, that's you.
Yeah.
Right. You've got to make this type of litigation attractive for the novice
Yeah.
legal students who might be thinking of coming into the career. So they are influencers.
No fun allowed here. They're not writing this bit down. Still got levels in the system, so they're going to crash. Authorize.
Mr. Chexwell, I gather the shorthand writer isn't back, but everything will be going onto a tape. So if there is otherwise, well, in fact, I see it's coming through now. So somebody somewhere must be recording what is being said.
Excellent. Yes, my lords, I was just taking you to these two paragraphs, which are set out under paragraph 80 in my skeleton. And I'm going to come on to some other points afterwards. These are really...
The first one is actually, you've just taken this to a moment ago, haven't you?
Yes, the two paragraphs are together under paragraph 80 in my skeleton. Yes.
No, sorry, 275 you took us to a few moments ago in Mr. Thomas's statement.
Must really like it. I hadn't picked it up. I apologise. And it's 276 as well as that. I'm sorry about the repetition. So there's that. Then the second point I wanted to draw to your lordship's attention is...
Sorry, I'm a bit struggling to understand the logic here. If you've got measurements that are carried out in trying to use a neutral term, two different systems, and you want to decide which of your measurements is the best, and you've obviously got to understand somewhere the relationship between the two different systems of measurement. That is necessarily the case, otherwise you can't possibly take the decision. So that much I don't understand to be in dispute. But the question is, why does it follow you have to convert one measurement to the other?
Well, it may be that there are other ways it can be done involving other steps and other processes.
Indeed.
The point in this case is that doing the conversion is an efficient way of doing it. And that's what the judge... I'm going to, in fact, go back to the benefits.
So would you accept that the mere fact that there's a comparison of some rough description being carried out does not impel the conclusion that there's been a conversion?
As a generality, that may be right. In the specific case of this standard, that's not right. The reason I say that is because the standard, as I showed my lords earlier, specifically says that the comparison is determined on the basis of the highest value of either RX lev or the equivalent under 8.1.5. So I think what my lord is positing is you could have dissimilar encoded values, but you could subject them to an algorithm, which means I know that a 17 is better on one level is better than a 24 on another.
Yes.
And you may be able to devise some kind of complicated system like that. I don't think that was particularly explored at the trial, and certainly wouldn't have the simplicity of our system. But what you can tell on the standard is you are doing a direct comparison of one encoded value against the other, because that's what the standard tells you to exactly do. It doesn't have any more complicated algorithm of the type that my lord is positing. So you know 17 is better than 16. And it's the same as 17 is less good than 18. And you know that at every point on the scale.
All right, but how do you reach the conclusion that there must have been conversion?
Well, I'm not sure I quite understand the question. If I can, I think my lord is saying, well, You can tell if there is a
Because
conversion.
what you're relying upon
Yeah.
is comparison of one value with another.
Yeah.
And you appear to be arguing, and I may have misunderstood, please tell me, you appear to be arguing that if there's a direct comparison, it necessarily follows that there's been a conversion. And that's what I'm struggling to understand.
A conversion has two aspects, or a converted value has two characteristics. It has the same format, and that's obviously a given here, and it has the second characteristic, which is the comparability, which, subject to the argument we've already touched upon about the degree of precision, means that a better value on one scale is better.
Yeah, one can understand conversion, therefore comparability. The question is, can you say comparability, therefore conversion?
Now,
the logic doesn't run this backwards, does
well,
it?
here, the comparison is done to determine the best cell, and I showed you, my lord, that. The comparison is between the two encoded values, whichever is higher. 16 is better than 15, 21 is better than 18. That's the higher one. Don't be the lower one, but the higher one is always chosen. And we know that's to determine the best cell. You could envisage a hypothetical system in which you do a comparison almost for no reason other than you have to make a decision. And so the results are predictable but arbitrary. And indeed, that was the case that was run in the first Huawei and Samsung case and rejected by the court there, and not run here. And the reason that that case failed then and wouldn't work here is because the standard says you're reporting the best cells. There are also three other points I want to refer to, which I think go to that point too. Now, the first of them is actually just how, and it's a simple point, but no lesser for it, but it's how the offset is described in the standard. And I showed that to your lordships a few minutes ago. It's at page 40 of the supplemental bundle. And what it says is an offset to be applied when prioritising cells. So the purpose of the offset is to give is a biasing offset, to give priority to different RATs, and that's exactly what we say the situation is here. You have inherent comparability and bias. My learned junior says it's a Ronseal offset. That's what it says on the tin. And that's kind of trite, but it actually makes the point in my respectful submission. Now, the next point I wanted to mention to my lords, which I showed you earlier, is that the offsets are applied as between GSM in and out of band. So you can have all of your cells within one band have the same offset, but GSM cells at 900 may have a different offset to GSM cells at 1800, for example. But those are identical systems. They are inherently directly comparable, yet you still have the same offset system being used. Now that's what the judge is referring to in fact, my lords, we looked at paragraph 138 a moment ago. I'm not sure if my lords read sort of the second half from the they may or may not have been. Can I ask if my lords haven't just that you do so, but it's particularly the last 4 lines which I want to emphasise for this point. 94 the bundle. So it's 94 the bundle, it's the end of 138.
Right, but can I be clear? the judge says the fact that offsets were added in level 4, the contention that the fact that offsets were added in level 4 proves that before the offsets were added, the numbers were not comparable, doesn't follow as a matter of logic. Would you accept it? It also doesn't follow that it proves that the numbers were comparable.
Yes, they may or may not have been, if I can speak my own tale.
Yes. Okay.
But in particular, but that's why the 4 points I'm referring to are ones in my submission that tell you which of those two is the truth.
And of course, with the GSM bands, you didn't need to do any conversion to achieve comparability.
No. And the point here actually, in a sense, ties in with my previous point, which is you've got one system of offsets which are described as being used to bias for or against particular rats or bands. You absolutely know with a certainty that that system is used as regards inter-band reporting, as it says, just as an offset. And then you've got to ask yourself on the balance of probabilities, with other points as well, but it's relevant to the balance of probabilities. Is that same system being used in the same way as it's described in the standard for the other inter-rats? Or is it in fact doing something completely different there? It doesn't prove in 100% sense that my learned friends are wrong, but it is certainly on my side of these scales. And the last point is also relevant. And one of the points that's been discussed is, as your lordships will recall, is that although at priority level 4 offsets are applied in the comparison process, it's the original unoffset values which are reported. And my learned friend's witness accepted that that was because those were the values which were useful in the network for the handover decision. So you know that those are the values which are being compared in the network for the handover decision. And that's a clear indication of comparability.
But that's one of the points that's relied on against you.
Well, it's
because it said that it's precisely because it's the original values that are reported. It's not converted values that are reported.
No, but that's a different point with respect, my lord. My lord, what the point I'm making is a question of fact. The fact that it's in the network, those are the values which are reported, is indicative. Sorry, in the network, those are the values that are used, is indicative they are obviously comparable, and we rely upon that. My learned friend's point is a different one, which is just, he says, if he's right about level 4, there's no infringement because something different is sent in level 3. But it doesn't, his point is a different factual point, is a different point with respect. His submission doesn't impact upon the evidential value of the fact that in the network, it's the unconverted values that are used. Sorry, I apologise, I've made a real slip there. The unoffset values which are used.
The unoffset but converted values, you say?
Indeed, absolutely, my lord. So, just to draw those together, my Lord Justice Arnold was right to raise a point to which I said they may or may not have been. But we say there are these, at least 4 indicia, and perhaps the last 3 are the most important, that weigh in the scales in my client's favour. As against that, there's nothing specific that my learned friends advance against it. There could be a system that existed which operated exactly as my learned friends said. That could exist. But we say all the evidence, and particularly these points, suggest that is not this system.
Sorry, we're not talking about a system here at all. We're talking about what the standard requires.
Okay, a standard that requires to operate in a different way. But we say that these are all fair bits of evidence which indicate that the way the standard requires the operation of a mobile device is to encode values in a manner which are comparable and then apply offsets so that you can bias for or against one different band or one different RAD. Now, I make 2 points. Firstly, my learned friend doesn't have any specific submissions that he puts forward to say that my analysis is wrong and that his client's assertion that there is no inherent comparability is correct. He says it could arise, but I say I've got specific reasons to say that it doesn't arise. And secondly, obviously this is the appellate court. The judge has made a finding. The judge heard extensive evidence and argument about this. And he said, I'm right.
So the finding of fact, you say, is paragraph 141.
Yes.
And where in that paragraph does he say anything about conversion?
Well, he's here considering, my lord, the characteristic of comparability, because 93 is where he construes the claim. And he construes the claim as requiring, as I say correctly, that the converted values, encoded values, have the format characteristic and the comparability characteristic. He analyses in the judgment those two characteristics sequentially. He analyses formatting in, I think, 128 to 130. Certainly 130 is his final one. So there he's done one of the characteristics. And then he goes on, in 131, say, turning to comparability, the second characteristic. And he considers down through to 140 the comparability characteristic. Now, having concluded on the facts that both of those characteristics are present in the manner of the encoding of the UMTS values when reported to GSM, he has satisfied the requirements of the claim, or has come to conclusions as a result of which the requirements of the claim are satisfied. So analytically, he has broken the analysis down of conversion down to consider those two characteristics separately, and one would expect any judge to do that. But what he says here is absolutely, what he says in 141, and my learned friend says it's confusing, this is just a recap of what's set out in 141. He's just recapping what my client's submissions were as summarised in 133. There's nothing confusing about this. It's just saying he agrees. So my learned friend, his skeleton, says, well, what does the sentence? That is why they're comparable, whatever values are selected for the offset. What the judge is getting at there is they are comparable. You may apply an offset to bias them, but that doesn't affect the underlying comparability. And he's rejecting my learned friend's argument that the comparability only arises out of the application of the offsets, which bring into alignment otherwise uncomparable or incomparable things.
And that's 140, I suppose. I agree that the schemes by which the values are encoded need to make the values comparable or not as a whole. Comparability does not exist if it's only present when the offsets are set.
Yes, yes. So if one reads, well, it's important, my learned friend's dotted around this section, it's really important for your lordships to read this whole section on comparability as a whole. And all the judge does, and I don't think this is particularly novel for a judge, he sets out one side's argument, he sets out the other side's argument, he summarises the evidence and his views on it, and then he reaches a conclusion. And the conclusion is, in 141, just to recapitulate my client's case. And that, he therefore concludes, satisfies a comparability characteristic. He's already dealt with format, and that's conversion. My lords, sorry, if I was going to move on unless you have any more questions on that. I have got some notes here on the submission my learned friend makes about conversion and value, and the fact that the 7-bit UMTS encoding and the 6-bit encoding as sent to GSM, a line with the same decimal value. And I think I've made my points on that. I don't want to go over them again. The main point, really, though, is this. It's just aimed at the wrong target. The patent is talking about if one looks at the example in the patent, it's talking about the comparison where it says RX lev equals RSCP plus offset. It's comparing, to go back to his table, the left-hand column and the middle column. His comparison of the middle column and the right-hand column is just to distract my lordships. And what's more, there is, to the extent it matters, and I say it matters not, there is the 5 decibel offset, which I've shown my lords already, between those two. And what's more, even if there wasn't, there's nothing to say the offset can't be 0 anyway. Sorry, let me just check I haven't missed anything that matters. No, sorry, unless you have any questions on that particular issue. I've got two very small points at the end of this section. Another argument Apple makes in its skeleton is that there's no evidence on this issue. I don't think that was pursued orally. It's always struck me as a bizarre point, and it's plainly wrong. I've addressed you on that, on the evidence. Oh, sorry, actually, I've dealt with my last point already. So unless I'm not proposing to say anything about version 8 of the standard for the reasons we've discussed. So unless my lords have any particular questions on essentiality.
Doesn't look to be the case, Mr. Klexford.
My lords, that takes us to the last hurrah, which is aggrevo. Now this is the case which has moved on markedly in my learned friends' oral submissions. And I will address your lordships briefly on that, and then go on to the substance of the argument. What is now said is that the conversion feature of Claim 1 is arbitrary, and therefore Claim 1 is invalid over what they and the judge calls T.1145. It's also somewhat more manageably referred to as Bordeaux. And unless it's problematic, I'm going to call it Bordeaux just because life's too short. Now, they say Claim 1 is invalid over Bordeaux on this basis, and they say the Satch claims, 8 and 16, are invalid also over Bordeaux too. And they put that on the basis that Bordeaux teaches using the Satch, and you heard that yesterday. Now, this is an argument which in my submission is genuinely problematic at a number of levels. The judge rejected the obviousness attack over Bordeaux in toto.
Well, you say that, but what about paragraph 210, where the judge says in terms that if conversion was an arbitrary in feature, then he agrees with Apple that the claim would be obvious?
Yeah, it's on the. Can I just build up to that, my lord? It's on the next page of my notes, so it's not a long. I think if I can just build up to.
And then you don't challenge that. There's no respondent's notice on that.
Well, can I just come on? Can I just explain the?
So in a sense, it's irrelevant what the basis for that finding was. The judge has made a finding. It's not in dispute. And the only question, therefore, is he wrong to reject the argument that it's an arbitrary feature?
Well, my lord, Apple do say there's no response notice, and they're right. But you've got to look at that in my submission in context. And I've got 4 observations to make on that. The first is that the judgment was written at a time when Loche and Bordeaux were in the case. So you can't take 210 too far. For Claim 1 over Loche, it was accepted that the only contested integer was conversion. So in that sense...
Sorry to interrupt. I just want to be clear what we're debating here. And my starting point here, in the light of what Mr Burkle said yesterday, is the grounds of appeal. So if we look in Core Bundle tab 2, page 11,
Yes, my lord.
So this is ground 7, the grounds of appeal. And what they say is the learned judge rightly held, paragraph 210, that if conversion was an arbitrary feature, then I agree with Apple that the claim would be agree obvious, had the judge correctly construed the principal claim, and in particular the conversion feature thereof, he would necessarily have found that the claim and all subsidiary claims to be aggrieved obviousness. So that's the ground of appeal, and it is in terms founded upon paragraph 210. Now, in those circumstances, in the absence of any challenge by your side to paragraph 210, what does it matter what the basis at trial was that led to 210?
Well, because, my lord, at trial, and indeed at the time that permission to appeal was sought and granted, that was true in the sense that we accepted that, for example, over Losh, the conversion was the feature that mattered. If conversion was thrown ignored, put to one side for the aggrieved argument, the claim wasn't. Claim 1, back to later claims, claim 1 was invalid. So the judge was right in his judgment, as it were, in the procedural context that was written.
Well, because changed because they're relying upon the finding which you say you didn't dispute.
Since then, when they filed their skeleton argument, my lord, which was just relatively short before the long vacation, they then said they're not pursuing Losh, having not pursued Bordeaux at all.
But they've plainly not abandoned their reliance on 210 because it's in the grounds of appeal and it's in the skeleton. So they are front and centre at this stage of the case, relying upon 210. The fact that they are not relying upon Losh as a conventional obviousness starting point is neither here nor there.
Well, it's Bordeaux. The things they're relying
All right,
on Bordeaux.
the same point applies. That's why I was saying earlier, it doesn't matter what the underlying basis for the finding in 210 is, because that's what they rely upon, and it's in their favour, and it's not challenged. And you tell us it's not challenged for the perfectly good reason it was common ground at trial.
Well, indeed, it was common ground at trial, but what's happened since is they've abandoned Bordeaux, and now they're trying to bring that back.
No, they haven't. They've not abandoned whatever was the basis for 210. You can't possibly say that when 210 is front and centre of the appeal.
Well, indeed, but my lords, you have my submission that things have changed. So when let me just.
But you've not identified any relevant change. You accept that 210 was based on something that was common ground at trial. It's relied upon as being the foundation for the ground of appeal that we are now considering, and it's relied upon in the skeleton argument, it's relied upon in the oral argument, never at any stage put in issue by your side. So what's the problem?
Well, my lord, my skeleton does put it in issue.
What? You're saying 210 is wrong? Where do you say that?
So no, I say if they're allowed to advance this argument at all. So when I discussed, I discussed 210. So, sorry, just to get the chronology though. At the time of the judgment, then 210 was right in the sense of, on the basis of Losh, that was the point in issue. And the reason, and I focus on...
Yeah, but Losh on its own doesn't establish obviousness. That's the point. What they need is a combination of prior art, be it Losh or be it Bordeaux, doesn't matter, and establishing that there's a feature in the claim that is arbitrary. And then the judge rejects that case, not on the basis that there's no starting point, be it Losh or be it Bordeaux. He rejects it on the basis that he doesn't accept that the claim has the conversion feature is arbitrary, and he in terms says if it was arbitrary, then it would succeed.
My lord, the concern I have, can I just put this in context? The concern I have is that in our submission, I'll show you this, claim 1 itself, even if the conversion feature is arbitrary, is not obvious over Bordeaux. And
in that case, you need a respondent's notice because you've got a finding of the judge against you.
But my lord, my lord, well, if that's what the decisions that your lordship come to, then I can't take the point on claim 1. Although I can take the point on claim 8, and the point essentially a similar point runs anyway on claim 8, because Bordeaux, the evidence was, and the judge's finding was that claim 8 is not obvious over Bordeaux. in any event. And that's the way my learned friend just puts it on board. Now, the reason if I may, my lord, may I just make my submissions on the procedural point? This is an important point. It's not a point of patent law, it's a general point. The judge made a finding on 210, which was correct in the way the case was constituted at that point in time. It's become incorrect in the way, in my submission, in the light of their skeleton argument, which abandons their prior art.
But how can they have abandoned a finding in their favour when they're explicitly relying upon it? I just don't understand it.
Because they're abandoning the premise upon which the finding was made.
Where?
Well, if I could ask rhetorically rather, what is the basis for saying that all the other elements of Claim 1 would be obvious?
They rely upon what the judge has found in 210.
Well, but the judge's basis for that is upon the cited prior art. There's no common general knowledge alone attack. The only basis the judge can have that. Now, I think, my lord, in my respectful submission, the question could be, should I have put in a response notice in September or in August or whenever, shortly after receipt of their skeleton argument? Obviously, that hasn't happened.
If you wanted to attack 210 when it was plainly being relied upon as the foundation for this ground of appeal, you needed to put in a respondent's notice and, moreover, put in a skeleton argument saying why the judge was wrong in 210. I still don't understand how you can say the judge was wrong when it's your own submission that he was right as matters then stood.
Well, indeed, my lord, my submission is as matters then stood, and matters no longer stand in that way. That's my
But you haven't identified any relevant change subsequently in circumstances where the appellant explicitly at all times has relied on 210.
Well, my lord, I don't think this necessarily benefits me making my submission again. I think my lord understands it. My lord will obviously reach a view upon that. But, and this is important, none of that goes to Claim 8.
Yeah. Now, I think at the moment that must be right. Can we just have a look at 210 to see what, if anything, he says about Claim 8? My recollection is you're correct, and he said nothing about it, but we ought to check.
Yeah. He doesn't. And there are findings in respect of this. There's evidence and findings in respect of the SATCH on Bordeaux, and I'm going to show you that.
Yeah, so you say 210 is a finding on its face about Claim 1 only. He says nothing about Claim 8.
Indeed.
Okay.
So, my lords, turning to the substance, we submit the judge was right for the reasons he gave. Now, in overview, the overview is as follows. The judge held at 211 that the conversion was not arbitrary. And as he says, at the risk of repetition, the conversion has the result, the converted values have again the two beneficial properties referred to above. I will not go over them again. These beneficial properties are shared by everything within the claim. In the case where beneficial properties exist across the full width of the claim, there's no reason based on Aggrieva or anything else why the inventors should have limited their claims to particular instances of taking advantage of those benefits. So you see the language there, which I've also adopted, about the judge distinguishing between benefits which are made available and the wider system taking advantage of them. That he reflects in 212 as well. Now, there's no appeal from this as a finding of fact. My learned friends obviously submit that it's not good enough in law that the fact the judge held the benefits are obtained across the scope of the claim, but plainly that's something I place reliance upon. Now, to recap, those benefits are the ones set out in 157. And for your note, as I mentioned to my lords yesterday, this should be read with paragraph 82 in mind as well. So the judge identifies here two benefits. and I'm going to deal with them in reverse order. First, there's the benefit of format substitutability, commonality of format leading to substitutability, which is beneficial in terms of the efficiency of the air interface. And I showed my lord some, I think it was cross-examination on that yesterday. Secondly, there's the benefit of having all the measurements on a single scale. That's what the judge refers to in 82 as being on the GSM scale. And this itself has two aspects. First, in the network, and I showed my lords this yesterday, receiving all the measurements on a single scale makes it easier for the network. And as I said, I showed you the cross-examination. Secondly, in the handset. Now this has two contexts to it. There is the context where the comparison is made between cells of two rats, and then the benefit is obvious, self-evident. But also where there is a comparison with a threshold, which is the question my Lord Justice Arnold asked me yesterday, or raised yesterday, then the same or similar benefits arise. And that's for two reasons. First, having the system and the handset all on the same scale, or I think yesterday I used the analogy of speaking the same language, provides simplicity in the system. And second, and this may be a less important point, but it's still a fair point nonetheless, the claim still enables comparison also to be made between cells of different rats. It doesn't require it, but it does enable you to make that as an additional level of decision making. Now I showed you some evidence from Dr. Thomas on this yesterday, but I should also have showed you a section of Mr. Simmons's cross which ties these benefits together across the network and the phone. It's in the supplemental bundle at tab 15, so it's T3, page 380. Hey, 249 of the bundle, sorry, 249 of the bundle. And it's 380 line 1 to 381 line 18. And it starts on that assumption, and the assumption is found on 378 lines 14 to 19. And it's just assuming, it's an assumption, I don't think it really matters. It's about what the alternative step 106 is, that just on only replacing other 106. But it relates to other questions, but I don't think it impacts on this bit at all. Anyway, that's the assumption. If I could ask you to read that down to 381.18, please. So the judge made the findings he did in 211 and 157, and as I've said, they're not appealed. And the conversion of measurements into values for the second communication system always results in these characteristics, since that's what the claim requires. It's a generally applicable principle or idea that supports in our submission to claims. Now, in terms of Apple's appeal, we say that Apple's appeal should be dismissed and is wrong for three independent but cumulative reasons, each of which is sufficient on its own, I should make clear. First, Apple's approach is wrong on the law. Second, even if Apple is correct in the law, its case fails on the facts. And third, even were the conversion to be considered arbitrary, its reliance on Bordeaux does not get it as far as Claim 8. I know it says Claim 1 either, but I think I'll focus on Claim 8 if I may. And Claim 8, of course, is entirely sufficient for all the infringement findings. That's uncontroversial. Now, turning to the law, Apple's case at its core is actually one of potentially very substantial breadth. They don't put it as such, but in my submission, Apple's case in fact represents a substantial extension to the argument in Agrevo, and in our submission, an unwarranted one.
Well, as I think Mr Birkle accepted yesterday, the argument isn't in truth based on Agrevo at all. It's based on a more refined principle which has come to be recognised subsequently.
Yes, but in my submission it goes even beyond that, and let me just explain to you why, if I may. So, Apple don't appeal the finding we've looked at in 211, but what instead they argue is that the conversion is arbitrary since the invention can be deployed in a wider system which takes lesser, or they say potentially even no, advantage of those benefits. And I know I've addressed you earlier about this, a little out of order, but you can see what I had in mind. So the divergence between the parties here is really at its core between the conversion which provides the benefit across the scope of the claim, or all conversions have those benefits, if I can put it in that way, and its potential use in a wider system which takes lesser, or Apple even say no, advantage of those benefits. So you could, for example, write a completely new message which was for UMTS measurements only, and so didn't take advantage of the format substitutability. Now from this they argue that the conversion integer is arbitrary and therefore the claim is obvious under Agrevo. But that does take Agrevo much further than that case, or indeed any of the development cases have gone. Now in Agrevo itself...
Well, can I see where you're going with this submission? The reason why I intervene at this stage is that Mr Birkle expressly accepted as correct the judge's self-direction as to the law. Now, given that Mr Birkle has accepted the judge's self-direction as to the law, are you challenging the judge's direction?
I'm sure I'm not.
In which case, need we say any more about the law?
Well, I think I'd really like to unpick exactly what it is that my learned friend is advancing. Because the point I was just going to make, the forensic point I was going to make here, is that, as I understand my learned friend's case, even had all the molecules in the Agrevo claim had herbicidal activity, the claim would still be bad. Now that's a pretty startling proposition. I'm sure he's not saying that, but I don't see a principal reason why that does not follow from the way he puts his case. And the reason I say that is because Apple's argument is that a benefit which is provided by the invention is not to be taken into account if the claim does not exclude embodiments that fail to take advantage of that benefit. You may recall in my skeleton argument, I gave the example of a high-performance carburettor which had advantages at high temperatures and high speeds, but was claimed as a product. And on my learned friend's case, that claim would have Agrevo features, those giving the high performance, the ability to perform at high performance and at high temperatures, because the claim did not exclude using it on a tractor mower. And obviously it's implicit when I say a tractor mower, that's something that does neither high speeds nor high temperatures. That's no different from their argument in this case. You could use that carburettor in an engine that operated at low speeds and low temperatures. And then going back to the Agrevo point I was just making. The claim in Agrevo was to a bunch of chemicals, but it did not exclude embodiments that failed to take advantage of the benefit, even had they all had herbicidal effect. So, on Apple's argument, they would say the herbicidal activity should be ignored because the claim does not exclude the use of chemicals added, say, to a concrete powder mix or to a baby milk powder mix. Now, in each case, no advantage has been taken from herbicidal activity. Yet in both of these, the presence of the Agrevo compound.
Yeah, but I don't understand that argument, because Agrevo itself was all about product claims. And here we're concerned primarily with a method claim. I appreciate there are product claims as well in this patent, but the argument is all focused on the method claims, and rightly so. So, and downstream uses of a product can't be anything to do with it.
Well, my lord, I've got to say, I do find this kind of argument easy to get my head around in the terms of the product claim. And that's why I have referred to product claims throughout. Just conceptually, I don't think a different result should follow. I haven't identified the different result should follow necessarily, but conceptually it's easier. If you think about it from the product claim, what we've got here is a set of components which result in produce the converted values, and which use the converted values. And all those converted values have these twin characteristics, just like the carburettor has the characteristics of operating at high speed and high temperature. And what they say, just like the tractor mower, is you might use them in a system that doesn't take advantage of them. Now, conceptually, I think and the reason I led off with the tractor mower example is I think that's clearer. I actually think, as a matter of logic, the same consequence does follow for Agrevo. But if it's easier, one can just focus on the as it were, the carburettor claim, or indeed, as I mentioned a footnote, my lord, the brake calipers and AP racing are a sort of more concrete example of this. So, in my submission, that's not what Agrevo is about. The fact an invention could be used in a wider system in which full advantage is not taken of its benefits, or even it's said none at all. I'm going to come back to that. That's not what the Agrevo is actually about. If I can put it another way, a patent is not to be invalidated just because it can be used or infringed badly.
Obviously not, but I'm still totally baffled as to what on earth this has got to do with the present case and the judge's reasoning. He states the law in 207. The principle is not that a claim which contains an arbitrary feature is valid. Merely having an arbitrary feature is not a ground of invalidity. The point is that if the claim is found an arbitrary limitation in it, then that limitation cannot assist the patentee in defending an obviousness case. And at the moment, both sides are accepting that as a correct statement of the law. So what does all of this discussion about infringing badly have to do with it?
My lord, maybe I can take that in two steps. The short and easy step is if my learned friend accepts the law in 207,
he does. Expressly accepted.
Well, indeed, and the facts in 211. Very hard to see why I'm on my feet at all.
Well, because he says 211 is based on a wrong construction of the claim. That's why you're on your feet. But of course, what you might be able to say is, assuming you're right on the construction of the claim, then that's the end of the case, because there's no dispute as to the law. If you're right on the construction of the claim, then the consequences follow.
Well, sorry, my lord, obviously I do say that. I do say that. I think one always feels a little naked making such a short submission as sitting down, although I suspect there'd be at least 3 people, probably a lot more in court, who'd be very grateful. What I'm really getting at, though, is I think my learned friend is being a bit, I was going to say clever, I don't mean that in any sense it's critical, it's his job to do that, but absolutely clear about that. But what I think he's really trying to say is he does accept 211, but nonetheless it is arbitrary. And what he's really trying to say, as I detect it, if I'm wrong on this, then frankly there's nothing in this point at all on his side, is he says it's arbitrary because the claim doesn't exclude you doing stupid things which mean you don't take advantage of the benefits, or doing things which mean you don't take advantage of the benefits. So what I think as I understand his case, what he's really trying to do is get round the finding that's not arbitrary by saying, yes, it's correct that everything where there's a conversion does have these benefits, but the system you may use systems which don't take advantage of those benefits, and therefore it's arbitrary nonetheless. That's how I that's how I understand his case. Because frankly, if that's not his case, he's accepted 207, he's accepted 2011. His point on construction, obviously if I'm right, I'm right. If I'm wrong, he doesn't say, he just says that makes his target a bit easier because the benefit of format substitutability falls away. But that doesn't deal with the other benefits that were found in 157 anyway. So that's not enough for him. That just takes out one of the links in the chain, and he doesn't appeal those other links anyway. So my lord, I notice the time.
You think this would be a convenient moment?
Yeah, but I think that might have been helpful to identify what at least I see the battleground to be. But my principal submission is, well, he accepts the judge is right on both of those, therefore I win, and it makes no difference if I'm wrong in construction. So my lords, I'm making good time. Well, in theory, I've got till 3:25, subject to the normal grenades and bombs that might come that direction, but I suspect I'll be pretty swift now.
Good. Well, thank you, and we'll start again at 2 o'clock.